I would like to welcome you to the lecture series Managing the Digital Transformation. My name is Christian Stauf and I'm a research assistant at Kaiserslautern University, and at the same time I'm also the managing director of the consulting company Beyond Innovation. So both areas of my professional life are concerned with innovation and the question of how a company can best protect and exploit its intangible resources. So this is what we will deal with today. My part of the event will deal with the protection and management of intangible resources. This question is of course of special interest in times of increasing digitalization. Currently, almost all companies are asking themselves what digital offers they can make to their customers and how they can manage to reap the fruits of their research and development work before competitors will do. In the past, this was actually relatively clear in the case of physical products, even though I can tell you a lot is still done wrong here, of course. I want to take a look with you at how modern IP management, which is what we are talking about here, must be designed in the age of digitalization. To do so, of course, we first need a few basics, which I would like to give you in parts number 1 and number 2. Of course, I cannot go too deeply into the subject matter here, as I do not want you to be overwhelmed with details. I would rather like to give you a little insight in the following. What is intellectual property? Why do companies need patents, trademarks, and all that stuff? Why should a company do intellectual property management, and what does it have to look like? I hope you will enjoy our session. Before we start, please let me first briefly explain where all the findings come from that I will share with you in the following slides. As I've already mentioned, we have been doing research on intellectual property at the Technical University of Kaiserslautern for many years now. And after numerous industrial projects, we were at some point, let's say, disillusioned to find that very many companies have no or only very rudimentary ideas about how to effectively protect their innovations. Many entrepreneurs had the idea that protection could only be achieved with expensive patents. Patents, and only patents. And if no patent protection is possible, then there is no protection at all. Moreover, practically nobody has seen the enormous value of IP for the company and understood that a targeted management of IP from a business point of view contributes to the success of the company. Many did not even know that it is possible to think IP in business terms. Yes, that's how Beyond Innovation was born. It was born out of this lack. And our team consists of Lena Kuhn, you can see her on the left side, Mr. Michael Hassemer, he is in the middle here, he's the professor and the head of the Department of Intellectual Property here in Kaiserslautern. And we also have Dr. Johannes Badens on the right side. He's a lawyer with a known chancellery here in Kaiserslautern as well. And there's myself and a lot of other young and motivated IP experts in our team. All in all, we are a very heterogeneous team of industrial engineers and lawyers, and also a judge, as you could see, because Michael Hassemer, he's a judge. And now for more than 5 years, we have been serving our clients as a competent partner when it comes to accompanying innovations from development to the market and optimizing corporate success with the help of individual protection strategies. So let's have a look at the agenda. In part 1, this is what we will deal with today. We will have a closer look at protection instruments. Part number 2 that we will deal with tomorrow is about intellectual property management. So after we have found some basic information about IP, we will talk about IP management. And in the final part, number 3, we will deal with the impact of digitalization on IP management. In recent years, IP, intellectual property, has become an important issue that companies are increasingly having to address. This is because we are in the middle of a knowledge-based economy with intense competition for the smartest minds, the biggest leaps in ideas, and the shortest innovation cycles. At the same time, the importance of intangible assets has increased enormously. By their very nature, they are difficult to grasp because they are immaterial and must be protected. Because of its strategic importance, IP must be managed at the top management level. And in fact, similar to digitalization, IP is now often a management issue, something that top management is concerned with. Meanwhile, a lot of companies are not only having a CDO, a Chief Digital Officer, but also a CIPO, a Chief Intellectual Property Officer. Companies such as Bayer or ThyssenKrupp have even founded their own companies, Bayer Intellectual Property GmbH, ThyssenKrupp Intellectual Property GmbH, and those companies exclusively deal with IP management within the group. What is meant when talking about the protection of innovation? I can tell you it is not about the protection of material objects like that car here. This is not a problem at all because we have paragraph 903 German Civil Code, Bürgerliches Gesetzbuch, which states, the owner of an object may deal with it at will and exclude others from any influence. That means just take your car, put it inside your garage and lock the door. So this way it is easy to keep others from using it. With other things like information, like technological knowledge, it's not that easy because it's just not possible to put it inside your garage and lock the door. So rather, it is about the protection of information that is contained in the physical object. That means the protection of non-physical, immaterial objects and resources. In particular, the protection of technical information, which primarily belongs to the inventor, who is, on the other hand, of course, usually not the owner of all Porsches. The protection of designs and information about business origin, for example, a trademark. And the protection of external product design. As you can see, intellectual property and physical property of the object fall apart. At this stage, maybe you will ask yourself why it is necessary to protect your intellectual property. I will try to explain it to you. Whereas only a few decades ago, classical physical production factors such as land or machines were dominant, the value added of modern companies today is increasingly based on the use of knowledge-intensive products, processes, and services. Intangible resources are meanwhile the key factor in today's globalized economy. This is mainly the consequence of the enormous competitive and innovative pressure to which companies are increasingly exposed due to the globalization of trade. In order to survive in this innovation-driven competition, companies are forced to produce innovation, for example, in the form of new products or processes. If you want to keep up, you have to be innovative. Those who want to be innovative must necessarily invest in research and development and thus ultimately in immaterial resources. However, the investment, for example in research and development, is usually significant and can, from the innovator's point of view, only be justified if the innovator is also able to protect the intellectual property created in the course of his innovation activity from being exploited by other market participants and to appropriate the resulting innovation revenues. Unfortunately, this is not always easy, as the ongoing discussions on product piracy show. On the one hand, there is a strong incentive for imitation. As you will know, there's a lot of cost-saving potential. If you do not have to do research and development on your own and you just copy what others are researching, it is quite cost-saving. On the other hand, immaterial resources have certain economic characteristics that are very similar to those of public goods. They are non-rivalizing in consumption, and there is no consumption through use. For example, take your car. If you are driving your car, no one else will be able to do that in the same time. And there is a consumption through use. Use your car for 500,000 kilometers and you will see that there is a consumption through use. But this is different with information. For example, technical information. If you use information at the same time, thousands of others can also theoretically use the information. And there is no consumption through use. The information is not getting less just because one person more knows about it. And much more important, third parties can only be excluded from use to a limited extent. Just like I told you, it's not that easy to lock an information in your garage. It is easier to protect your car by putting it inside your garage. Not with information, it's not that easy. And in addition, we have high fixed costs with low or even no marginal costs. So in sum, there is a high risk that the profits from innovation will be skimmed off by free riders. The profits and the profitability of innovation efforts is reduced this way, and we create a problem of appropriation. The costs of the underlying research and development may even exceed the benefit of the inventor company. And in the end, we have an incentive problem for future innovation activities. Because why should I be innovative? Why should I do research and development if I'm not able to exclude others from using what I just figured out? The protection of intangible resources and the appropriation of the corresponding innovation revenues are therefore indispensable. I think it has become clear that there is a need to protect immaterial resources. And consequently, now we have to raise the question of how we can protect our intellectual property. What kind of instruments are available for a company? First of all, we need to distinguish between two types of protection instruments. First of all, we have legal instruments like patents, utility models, trademarks, design, copyrights, and some others. Those give their owners a right to prevent others from making, using, or selling the intangible asset without permission. For example, an invention or a trademark. In this way, a temporary monopoly is established which allows the owner of the intellectual property right to exclusively exploit his intangible resource for a certain time. An exception is the trademark, which can be renewed every 10 years and thus offers potentially perpetual protection. Please remember, intellectual property rights do not permit anything. They only allow their owner to prohibit others from using and exploiting them. For example, if you hold a patent in the field of nuclear technology, this doesn't necessarily mean you are allowed to use the invention yourself. But the patent gives you the right to prohibit others from using this technology. By doing so, intellectual property rights encourage companies to make the necessary investment for innovation and provide the incentive for individuals and companies to devote resources to research and development. And we have a second category of protection instruments, non-legal de facto instruments. For example, trade secrets. State and federal trade secret laws protect sensitive business information. An example of a trade secret would be a confidential marketing plan for the introduction of a new software product or the secret recipe for a brand of salsa. For example, Coca-Cola. The recipe is still secret. That would not be possible with a patent because a patent only gives protection for 20 years. The extent of a trade secret protection depends on whether the information gives the business an advantage over competitors, is kept a secret, of course, and is not known by competitors. Furthermore, companies often use technical protection measures to prevent consumers from being misled as to the origin. For example, they are using RFID tags, barcodes, holograms, and so on. Another possibility is the control of complementary goods that can be achieved by establishing exclusive distribution channels or by limiting the production capacities, for example, of competitors. If you are the only company that offers sufficient production capacities, that will be a real obstacle for competitors. Many companies systematically use a complex product design that makes re-engineering much more complicated and that helps to maintain information asymmetry. Furthermore, companies use contract design, which means the drafting of contracts with suppliers and employees, for example. And the first mover advantage, very often being the first on the market in order to establish a sustainable competitive advantage, is the best way to protect your intellectual property. So let's have a closer look at the legal protection instruments. First of all, the patent. Everyone knows the patent. Sometimes people think they know something about patents and they are talking about patent wars between Apple and Samsung. But in fact, the war, if you call it a war, between Samsung and Apple is not about patents. It is very often about designs, about the appearance of their products. So if someone is talking about patents in an international context, you have to be very careful. A lot of people are not distinguishing between the different intellectual property rights. A patent is something completely different compared to a trademark or a design protection. So if you hear patent wars between Apple and Samsung, it is very likely that there is no patent war, but they are arguing about the design of their products. Sometimes it's called design patent, and therefore the confusion. So what is a patent? A patent is a legal title, an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. A patent can be granted for any invention having a technical character, provided that it is new, involves an inventive step, and is susceptible to industrial application. To get a patent, technical information about the invention must be disclosed to the public in a patent application. The patent owner has then the exclusive right to prevent or stop others from commercially exploiting the patent invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's permission. Usually, the protection is granted for a limited period, generally 20 years from the filing date of the application. Please remember, patents, like all other intellectual property rights that I will present to you now, are territorial rights. In general, the exclusive rights are only applicable in the country or region in which a patent has been filed or granted, in accordance with the law of that country or region, of course. Another instrument is the utility model. A utility model is a registered right that gives the holder exclusive use of a technical invention. In some countries, utility models are sometimes referred to as petty patents or innovation patents. Although there is no European Union-wide utility model protection, the Commission monitors the economic impact of utility model legislation. In some countries, a utility model system provides protection of so-called minor inventions through a system similar to the patent system. Recognizing that minor improvements of existing products which does not fulfill the patentability requirements may have an important role in a local innovation system, utility models protect such innovations, such inventions, through granting an exclusive right, which allows the right holder to prevent others from commercially using the protected invention without his authorization, for a limited period of time, of course. In Germany, it is 10 years. In general, compared with patents, utility model systems require compliance with a lower requirements. For example, lower level of inventive step. They have similar procedures and offer shorter term of protections. Designed primarily to respond to the needs of local innovators, requirements and procedures for obtaining protection and the duration of protection vary from one country to another. Another very important legal instrument is the trademark. Trademarks identify goods and services of an enterprise, of a company, and they are its intellectual property just like patents. Strong trademarks are real assets, as you will know. Look at Coca-Cola, for example. They really have a very strong and valuable trademark. And sometimes companies' most valuable assets are trademarks. If you compare the worth of a company, of its physical assets, to their immaterial assets, you will discover that the immaterial assets are much more valuable than the material ones, the physical ones. And this is the case for nearly all companies that I know. If you think about Google, Amazon, Coca-Cola, and so on, their brand names are very expensive meanwhile. Above all, those signs can be protected as trademarks that are suitable for distinguishing goods and or services of a company from those of another company. But we have some certain requirements for protection. First of all, the essential function of any trademark is to guarantee the identity of the origin of the marked goods or services to the customer. In order to fulfill that function, a trademark must be able to distinguish itself from other marks or signs. Distinctiveness impacts on everything from the registrability of a mark to its scope of protection, its enforceability, and its continuing validity once registered. A distinctive mark distinguishes a company's goods and services from the goods and services of competitors. So it needs to be distinctive. It needs to have a unique character. A non-distinctive mark, on the other side, simply describes and names a trait or quality of goods or services and thereby identifies one or more characteristics of a product or a service covered. It only serves to describe the product. If you take, for example, Apple, the logo of Apple for a fruit shop, it's just describing what is sold there. Or if you take diesel, the word diesel for fuel, it just describes the product. And this is not possible. It's not possible to have a trademark that describes just the product. In addition, a trademark may not be similar or identical to existing trademarks used for similar goods and services, because in this case we have a likelihood of confusion, and this is not allowed. This should be avoided. And as you can see on the right side, let me put on the laser pointer, you will see different types of logos. As you will know, we have logos like words, Telekom. This is a trademark, a German trademark, as you can see here. Or we have so-called figurative trademarks, logos like Apple, or mixed combined word and figurative trademarks like BMW here. With this it's easy, you will know that trademarks. What you will maybe not know is that you can also have a trademark for a color, like here, the magenta of Telekom. This color is for the goods and services Telekom is offering, it is protected. And what you may also not know is that Telekom has also protected its jingle, so you can have sound trademarks. Do you know that from Telekom, the this is a trademark, a sound trademark. And if you see the rabbit from Lind and the bottle of Coca-Cola and the Porsche Boxster, they have something in common. All three are protected by three-dimensional trademarks. Yes, this is possible. And it is also possible to get a protection, to get a trademark for a slogan. You can see it for the Audi slogan, Vorsprung durch Technik. That is a German trademark. So as you can see, we have many different types of trademarks. Furthermore, we have design protection, so-called designs. In Germany, we have a design law. The European Union has a so-called Geschmacksmusterrecht, Gemeinschaftsgeschmacksmuster. What is it? Registered designs protect the appearance of industrially manufactured or manually crafted products. An industrial design may consist of three-dimensional features such as the shape of an article or two-dimensional features such as patterns, lines or colors. Parts of products can also be protected by a registered design. For example, the sole of a sports shoe, as you can see here in the middle. The slide also shows plenty of other examples. We have, for example, a chair made of a cardboard box, or a mudguard, an engine hood that is also protected by a design, or as I just mentioned, the shape of a shoe or the sole of a shoe. Something which is protected in which was protected in 2018 by Apple are those emojis you can see down there. Emojis and emoticons are protected by designs. Yeah, it's crazy. And also the appearance of the iPhone is also protected by a design. So as you can see, registered designs are very important for industry. But that raises the question, what kind of protection does an industrial design right offer? In principle, the owner of a registered industrial design or of a design patent, that's how it's called in the USA, has the right to prevent third parties from making, selling or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. Through a registered design, the German Patent and Trademark Office, das Deutsche Patent- und Markenamt, grants a limited monopoly on the appearance, that means the shape, pattern and colors of a product. So how are industrial designs protected? Yeah, in most countries, an industrial design needs to be registered in order to be protected under industrial design law as a registered design. In some countries, industrial designs are protected under patent law as design patents, like in the US. Industrial design laws in some countries grant, without registration, time and scope limited protection to so-called unregistered designs. Or unregistered industrial designs. Depending on the particular national law and the kind of design, industrial designs may also be protected as works of art under copyright law. Let's make clear that you do not have to know this in detail. I just want you to be able to distinguish between the different types of intellectual property rights. And I want you to know that there's more than patents. We also have trademarks, we have designs, and we have copyrights that we will have a look next. The copyright or author's right is a legal term used to describe the rights that creators have over their literary and artistic work. Works covered by copyright range from books, music, paintings, sculptures, films to computer programs, databases, advertisements, maps, or technical drawings. Copyright protection extends only to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. This is very important. Copyright may or may not be available for a number of objects such as titles, slogans or logos, depending on whether they contain sufficient authorship. So the question raises, what rights does copyright give me? What are my rights as an author of a work? Yeah, there are two types of rights under copyright. First of all, the economic right, which allows the right owner to derive financial reward from the use of their work by others. And on the other side, the moral right, which protects the non-economic interests of the author. Most copyright laws state that the right owner has the economic right to authorize or prevent certain uses in relation to a work, or in some cases, to receive remuneration for use of their work, such as through collective management. The economic right owner of a work can prohibit or authorize its reproduction in various forms, such as printed publication or sound recording. Its public performance, for example, such as in a play or a musical work. Its recording, for example, in the form of compact discs or DVDs. Its broadcasting by radio, cable or satellite. Its translation into other languages, and its adaptation, such as a novel into film screenplay. Very often I am asked if I can register a copyright. But I have to tell you, in the majority of countries and according to the Berne Convention, copyright protection is obtained automatically without the need for registration or other formalities. Most countries nonetheless have a system in place to allow for the voluntary registration of works. Such voluntary registration systems can help solve disputes over ownership or creation, as well as facilitate financial transactions, sales, and assignment and or transfer of rights. This is something that we do not have in Germany. Beyond the legal protection instruments that we have discussed above, there are also other ways to protect innovation against imitation by competitors. We are talking about the so-called de facto measures, and I would like to briefly mention secrecy as one of the most important. From a company's point of view, it might make sense not to apply for an intellectual property right and thereby disclose the information, for example, because the protection provided by law in this certain case does not satisfy the company's protection needs in the best possible way. At this point, confidentiality offers a strategic alternative to intellectual property rights. One of the best known examples of trade secrets is probably the recipe for Coca-Cola's soft drink, which has been kept secret for decades and which could in principle have been patented. So let's raise the question, how does secrecy actually work? The protection is based on the idea to prevent the publication of innovation-related information. This can be done, for example, by ensuring that only a limited circle of people have access to or use certain knowledge. It is important to understand that the effect of secrecy is not, as with intellectual property rights, based on the owner's ability to prohibit third parties from using it. Know-how protection does not offer the right of prohibition, such as a patent, which gives its owner a temporary monopoly. I was describing that just before. The protection of know-how, therefore, does not prohibit the use of the secret information itself, but what does the protection of know-how do? It only sanctions the overcoming of the precautions taken for the protection of the secret. That means it sanctions unfair disclosure, for example, by industrial espionage. At the same time, however, it means that if innovation-relevant knowledge becomes known through negligence in the protection of the secret, the protection is completely lost. You should therefore note at this point, know-how is not defenseless. Since 2019, there has even been a separate law which regulates know-how protection. In Germany, it's called Geschäftsgeheimnisgesetz. But nevertheless, the intellectual property rights will in most cases be superior to the know-how protections in terms of effectiveness, as they grant their owner a strong right of prohibition. Keep this in mind, but consider as well that this protection instrument must be included as an important element in a systematic and holistic IP management approach. We will have a closer look at this in part number 2. So this was really tough. We were running through the different intellectual property rights, which is usually something that you learn within a whole semester when you visit the lectures of Professor Hassemer. But this was just to give you an overview that you can see we have different legal protection instruments, and now I will tell you that you should use all of them if possible. But first of all, let's talk about psychology. Now you know what you should protect, you know why you should protect, and you know how you can protect your intellectual property. You know the different instruments. But you will as well observe very frequently reservations regarding legal protection measures. For example, a lot of people say they are complicated, they are very expensive, and some say that they are ineffective, possibly because enforcement in other countries is difficult. And something that is often criticized, you have to disclose your technical information when applying for a patent, for example. And of course, there is a risk of circumvention of protection by competitors. The so-called inventing around is getting possible. And we have a risk of refusal of protection after disclosure. We also have the risk of invalidity proceedings, no question. And the disclosure of information in a patent allows competitors to draw conclusions about your research and development activities, for sure. You also have to admit that disclosing technical information can wake sleeping dogs by drawing competitors' attention to interesting areas of technology. And very often we have uncertainties in surveillance and enforcement, especially in other countries. But does that mean that we should not apply for a patent, that we should not use any intellectual property rights? For me, it's very clear that the answer is no, and in the following slides I will show you why. To do so, I will use an example that was presented at the IP Service World 2016 in Munich by David Kapos, the chief of the US Patent Office. And I would like to show you what a company without an IP strategy, or in general without intellectual property, can face. The manufacturer Sullivan Sports sells all kinds of camping accessoires, including the trailer models that you can see on the top here. The head of the US Patent Office, Mr. David Kapos, has reported that the head of the company has called him and complained about an Asian competitor that was offering similar products at Alibaba.com, confusing them with each other. Namely this one. As you can see, TDR has not even bothered to change the advertising for the imitations. Despite all justified indignation, Sullivan Sports could not do anything against the competitor who copied his own products in this case. The company had no intellectual property rights that could have prevented imitation. After all, the principle applies: what is not explicitly protected may be imitated, because we have freedom of imitation. So you have seen what can happen when you have no intellectual property rights at all. Another example to give you a contrast is the company NeoPearl and its Erater Cascade. I would like to give you that example to show you what intellectual property and a well-designed IP strategy are capable of. The NeoPearl Erater Cascade is distributed on the European market. The company has had this patented. A third company has illegally inserted imitations into the shower heads and sold them in specialist shops. On the right side, you see the original, on the left side, the plagiarism. Both are hardly distinguishable from each other, in my opinion. What happened? Neopearl took the counterfeit products off the market and destroyed them. And they were able to do so because they had applied for the corresponding intellectual property rights. If you now take a closer look at the laws, an intellectual property rights holder is entitled to a wide range of claims. You have claims for damages, injunctive relief, claims for destruction, and many more. And last but not least, this simple example shows you, or you can see in this example, what an intellectual property is. Intellectual property rights are power. Therefore, I think it is worth taking a closer look at the advantages of intellectual property rights. Intellectual property rights are rights granted by the state, which give the owner a temporary exclusive right, a temporary monopoly for commercial use. If we just look at the patent, a great advantage is its non-appealability. Non-appealability does not have to be proven in infringement lawsuits. This is something completely different when dealing with trade secrets. When having a trade secret, you first have to prove within a lawsuit that you in fact have a trade secret. And as I already mentioned, we have a lot of different claims in case of infringements when dealing with intellectual property rights. For example, the right to injunctive relief, the claim for damages, the right to destruction, the right to information, and many more. Furthermore, intellectual property rights offer a strong legal protection. In contrast, trade secrets do not prohibit the use of the information itself, but only the overcoming of de facto secrecy protection. This is something that is not as strong, let's say not as strong as special protection offered by intellectual property rights, because it just offers protection against unfair disclosure, for example, industrial espionage. If the secret is lost through negligence, protection is lost as well. And in addition, we have no protection against double inventions when not having a patent, for example. If a single inventor or another company applies for a patent, the company that is using the technology and has no patent will maybe not be able to use the technology in the future anymore. And in addition, there are external options for exploitation. If you have intellectual property rights, you can sell or give licenses. You can grant a license to a competitor, for example, and earn a license fee. And in addition, we have a lot of different functions when talking about intellectual property rights. I will give you an impression on the next slides. For sure, the main motive of intellectual property rights is certainly the protection of the own intangible assets. The company wants to protect these from imitation by competitors. But at the same time, the ownership of own intellectual property rights should make sure that the company's own freedom of action is not restricted by the intellectual property rights of third parties. This is referred to as freedom to operate, FTO. However, intellectual property rights do not only have a protective function. They also have numerous other functions, so-called strategic functions, which we will discuss in more detail below. One very important function is the blockade of competitors. Results of research and development are not always turned into products. However, patenting can still make sense from a company's point of view because the right to prohibit others from giving by patents does not depend on whether the invention is used by the owner or not. Therefore, the purpose is not to actively use the invention. Rather, we want to prevent the use of the technology by other companies and to deliberately hinder research and development activities of competitors. We distinguish between offensive blockade and defensive blockade. When dealing with offensive blockade, we talk about so-called patent walls. A company establishes patents around the own product in order to prevent competitors from protecting a new technical development similar to one's own product or from transferring an innovation from a neighborhood field of technology to an application area in which one's company is active. The protection is broader in scope than is actually necessary to protect the actual innovation. We're talking about patent walls or thickets. The aim is to protect a broad field of technology around the own core patent from possible circumvention, inventions, and further developments by competitors, thus keeping potential competitors at a distance. As it is a very expensive strategy, a patent thicket is only justified if the returns made with a protected product is quite huge. If money is an issue, a wall, which means a single line of defense, might do the same job as a patent thicket. For example, pharmacy. A pharmaceutical company has developed 5 different active substances against a disease that has so far been hardly treatable successfully. Since the approval of a drug is expensive and lengthy, only one of the developed patents is used. The other 4 serve as blocking patents to prevent competitors from entering this market, thus securing the economic success of the entire development. Another type of offensive blockade is the so-called bracketing. Around a competitor's basic patent, a patent network is built in order to restrict his future technological freedom to operate and to make it more difficult for him to develop his innovation. The holder of the fenced patent is thus de facto forced to either develop circumvention solutions, which is time-consuming and costly, or to acquire corresponding licenses or conclude cross-licensing agreements. Finally, we have a defensive blockade. Here, the idea is to use patents to secure a field of technology for the company at an early stage. In order to prevent a restriction of the company's own future technological scope through third-party intellectual property rights, and at the same time, we want to avoid possible patent infringement suits by third parties. Another strategic functions of intellectual property rights is the reputation. Maybe you know the company Gillette and his advertising patents. Gillette is using the advertising function of patents very intensively, with 20 patents on our blade technology. And you can see the first Gillette shaver patent is from 1904. Intellectual property rights can also obviously be used to improve the reputation of a company, to give the company a technological image. Another strategic function of intellectual property rights is exchange. Intellectual property rights improve the access to the capital market, because banks are now accepting intellectual property rights like patents or trademarks as banking collateral. And in addition, intellectual property rights are improving the position of the own company in corporations. In many industrial sectors, especially in the information and communication industry, we are experiencing that participation in the market activities is hardly possible without own intellectual property rights. Established companies bundle their rights in so-called IP pools and allow others access if they grant access to their IP in return. One example is the new G5 technology, for which so many intellectual property rights already exist that without your own rights and the associated possibility of granting others access to them, you don't stand a chance, because otherwise you would violate the intellectual property rights of third parties. A very good example is Tesla. Originally, CEO Elon Musk wanted patents to prevent other major car manufacturers from copying Tesla's technology in the e-vehicle sector and thus pushing Tesla out of the market. But meanwhile, which is very surprising, Tesla is offering free licenses to competitors, and that's for a reason. Why is Tesla doing that? Because we all know there is no free lunch. The answer is simple. Tesla wants to establish its technology as fundamental technology on which follow-up products are based. And this gives them access to intellectual property rights of their competitors. We call this grant-back licenses. Furthermore, many protection instruments also have a certain incentive function. Among other things, they contribute to increasing the motivation of research and development employees, for example, by being named as an inventor in patent applications and by receiving an inventor's remuneration. In addition, applications for intellectual property rights and other publications sometimes also serve as an internal performance indicator, for example, for the performance of the R&D department. Last but not least, another strategic function is the deception of competitors. Applying for patents to deceive competitors can be part of the strategy. We call this confusion patents, and they intend to deceive competitors and give a false picture of their own research and development work. Such patents can be created at low costs, for example, as unusable variants of actual innovations. Even if, for example, the examination fee is subsequently not paid, the patent application is published and may mislead the competitor as to the direction of his own development.